There are moments in a courtroom that no one forgets. Not the verdicts, not the sentencing, not the tears from families sitting in the back rows, pressing tissues to their faces while they wait for someone to tell them that justice is real. No. The moments that stay with you, the ones that career lawyers still talk about in quiet corners of law libraries 30 years later, are the moments when the entire room goes still, when something happens that no one expected, when the system, the institution, the authority of the law itself turns inward and says, enough. I've studied courtrooms for over 2 decades. I've reviewed transcripts, sat in public galleries, spoken to attorneys, clerks, and judges who've given their lives to the law. And in all that time, I've only encountered a small handful of cases where what happened inside that courtroom was so extraordinary, so direct, and so publicly witnessed that it changed the way I understand how justice actually works when it works the way it's supposed to. This is one of those cases. What I'm about to tell you involves a judge, a sitting, appointed, credentialed judge, who walked into his own courtroom and attempted something that should have been impossible. Something that defied not just legal ethics, but common human decency. He stood in front of a jury and threatened them, not subtly, not with the polished, deniable pressure that sometimes seeps into courtrooms like cold air under a door. Openly, directly, in front of witnesses. And what happened next happened fast. His name was the Honorable Gerald Weston, and for 17 years, that title had meant something in Crestfield County. Judge Gerald Weston had come up the hard way, or at least that's what he said at every dinner, every bar association reception, every ceremonial occasion where his biography was read aloud by someone who hadn't actually read it. He'd grown up in a mid-sized city in the Midwest, gone to law school on partial scholarship, clerked for a district court judge, worked a brief stint in the prosecutor's office, and then, through a combination of political connections, local reputation, and what people in the courthouse called the right handshakes at the right fundraisers, he'd ascended to the bench. For the first 8 years, he was considered fair, stern but fair, precise with procedure, consistent in his rulings. Attorneys who appeared before him knew what to expect. He ran a tight courtroom. He didn't tolerate theater. He believed in efficiency. But somewhere around year 9, something began to change. It wasn't dramatic. It rarely is. Power doesn't usually corrupt in one clean break. It erodes slowly, in the way that water works through stone, patient, persistent, invisible, until the damage is already done. Small things at first. A sharpness in his tone when attorneys challenged his rulings. A habit of cutting off defense counsel mid-sentence that went slightly beyond judicial efficiency into something that felt more personal. A growing impatience with juries, with their questions, their notes, their requests for clarification, that began to read less like judicial authority and more like irritation. Courthouse staff noticed. They always notice. The clerks, the bailiffs, the court reporters who sit through every session and hear everything, they began to talk quietly among themselves. The way you talk when you're not yet sure whether what you're seeing is a problem or just a difficult personality. By year 12, it wasn't just personality. There were complaints, 3 of them, formally logged with the State Judicial Conduct Commission. An attorney who alleged that Judge Weston had dismissed her motion for continuance in a way that unfairly prejudiced her client, and then made a comment in the hallway afterward that she documented word for word. A public defender who claimed that Weston had rolled his eyes visibly during closing arguments in a case where the defendant was ultimately convicted. An expression caught on the courtroom camera feed and reviewed afterward. A court reporter who filed an internal concern after Weston made a remark during a break. Off the record, she thought, that indicated he had already made up his mind about a case before the defense had finished presenting. Each complaint was reviewed. Each one was resolved with a finding of insufficient evidence, or categorized as a difference of judicial opinion, or quietly filed away in the manner that institutions sometimes use to protect their own. Weston was never formally sanctioned. And so he continued. The case that finally broke everything open came in the fall of a year that had already been contentious for Crestfield County. There had been a major civil fraud suit working its way through the court system for nearly 2 years, a case involving a local property development company accused of systematically deceiving elderly investors into sinking retirement savings into projects that were either grossly mismanaged or deliberately fraudulent, depending on which attorney you asked. The defendants were well connected, the kind of connected that, in a smaller county, means something. They had contributed to local political campaigns. One of the principals sat on the board of a charitable foundation that had publicly honored Judge Weston the previous spring at a gala dinner attended by most of the county's legal and political establishment. The plaintiff class was made up of 47 individuals. Most of them were retirees. Several were in their 80s. A few had already died in the 2 years the case had been in litigation, their families carrying the claim forward. One woman, her name was Elaine Marsh, and her presence in that courtroom gallery every single day of the trial was something every attorney who was there has mentioned when I've spoken to them, had lost over $200,000. Her entire retirement savings. She was 71 years old. She sat in the gallery in the same gray cardigan every day and took notes in a yellow legal pad with careful handwriting. The jury had been selected. 12 individuals, carefully vetted, who had listened to 6 weeks of testimony, expert witnesses, financial records, recorded phone calls, emails with damaging timestamps. The kind of evidence that builds slowly and then all at once becomes unmistakable. By the time closing arguments concluded, experienced attorneys on both sides privately described the evidence against the defendants as overwhelming. Not complicated, not ambiguous, overwhelming. The jury went into deliberation on a Tuesday morning. By Wednesday afternoon, they had sent a note to the judge. The note, which later became part of the public record, indicated that the jury had reached a unanimous decision on the primary question of liability. They were asking for clarification on how to proceed with the damages calculation phase of their deliberation. Standard procedure. In a complex civil fraud case with multiple plaintiffs and varying loss amounts, juries often need procedural guidance when they've reached the liability phase and need to move into damages. What happened next was not standard. It was not procedure. It was not anything that a courtroom should ever witness. Judge Gerald Weston called both legal teams back into the courtroom. He had the jury brought in from the deliberation room and seated. He looked at the jury note. And then, instead of providing the procedural clarification they'd requested, he spoke directly to the jurors in a manner that every person in that courtroom would spend years trying to accurately describe. He told them, in language that the court reporter captured in full, that he was concerned about the pace of their deliberations. He told them that in his experience, juries that moved too quickly toward a decision sometimes failed to fully consider the professional and personal consequences their verdict might have, not just on the parties in the case, but on the community, on local businesses, on the kind of investment and economic activity that kept a county like theirs functioning. He paused there. He let that sit. Then he said, and this is in the transcript, word for word, that he hoped the jury understood that their role was not to punish success, that the plaintiffs had made investment decisions of their own free will, that the jury should be careful about how their verdict might be interpreted by the broader business community watching this case. There was a moment of absolute silence in that courtroom, the kind of silence that happens when everyone in a room realizes simultaneously that what they just heard cannot be unheard. Several jurors exchanged glances. One, a retired schoolteacher named Howard Gaines, who would later give a statement to the Judicial Conduct Commission, described feeling physically cold in that moment, like the room temperature had dropped. The lead plaintiff's attorney, a woman named Sandra Oku, who had been practicing civil litigation for 23 years and who by her own description had never once in her professional life done what she was about to do, stood up before the judge had finished speaking. She said, "Your Honor, I need to formally object to everything you just said to this jury." Weston looked at her with an expression that those who were present described as genuine surprise. He was not accustomed to being interrupted. He was not accustomed to being challenged in his own courtroom. He told her to sit down. She didn't. She said that what the judge had just communicated to the jury constituted jury tampering, that it was a direct attempt to influence the verdict through intimidation and economic coercion. She said she was making a formal record of her objection and requested an immediate mistrial. The defense attorneys were silent. One of them later told a legal journal that he had known immediately, in that moment, that the judge had just destroyed his client's case far more completely than any jury verdict ever could have. Weston's face changed. Something shifted. The surprise became something harder, and he told Sandra Oku that she was out of order and that if she didn't sit down immediately, he would hold her in contempt. Sandra Oku said, "Your Honor, you may do that, but I want the record to reflect that I am standing here in front of this jury because I believe what just happened was a criminal act performed by an officer of this court, and I will not be silenced." The court reporter's hands were moving the entire time. What happened over the following 48 hours was a cascade. Sandra Oku's formal motion, filed that same afternoon, triggered an emergency review by the State Judicial Conduct Commission. Two of the jurors, Howard Gaines and a woman named Patricia Delgado, independently contacted the commission's office and provided written accounts of what the judge had said. These accounts matched the court transcript precisely. A bailiff who had been present in the courtroom provided a voluntary statement confirming what he had witnessed. The commission moved with a speed that surprised everyone who had been watching this process for years. Within 36 hours of the incident, Judge Gerald Weston was suspended from his duties pending a full investigation. He was prohibited from presiding over any active cases. His courtroom was reassigned. His access to the judicial system's case management network was temporarily revoked. By the following week, a special master had been appointed to review all cases over which Weston had presided in the previous 5 years. The scope of that review would eventually expand to include cases dating back nearly a decade. Weston retained private counsel. He issued a statement, through his attorneys, that his comments to the jury had been mischaracterized, that he had been attempting to provide context, that he had been speaking generally, and that his words had been taken out of context in a moment of heightened courtroom tension. The court reporter's transcript contained no contextual ambiguity. The investigation found that Weston's conduct on that Wednesday afternoon constituted a clear violation of judicial ethics codes, that his comments to the jury were, in the formal language of the commission's findings, an attempt to improperly influence jury deliberations through intimidation, and were inconsistent with the duties and obligations of a sitting judge. The commission recommended removal. The state Supreme Court, reviewing the commission's findings, unanimously agreed. Gerald Weston was removed from the bench. His judicial career, 17 years in the making, ended in the formal language of a 4-paragraph order from the state's highest court. He never presided over another case. The civil fraud case was retried before a new judge. The jury in the second trial deliberated for less than a day. They returned a verdict in favor of the plaintiff class. The damages award was substantial, in the millions, distributed among the surviving plaintiffs and the estates of those who had died during the years of litigation. Elaine Marsh was in the courtroom when the second verdict was read. She was still taking notes on a yellow legal pad. She didn't cry. People who were there said she just wrote down the verdict amount, very carefully, in the same handwriting she'd used every day for 2 years, and then she closed the notebook and held it in her lap. What does a story like this mean? I've thought about that question for a long time, and I think the answer lives in the details that are easiest to overlook. It's easy to focus on the dramatic moment, the judge threatening the jury, the attorney standing up, the removal order. Those are the scenes that stay with you. Those are the moments that feel like justice, functioning the way we're taught it's supposed to function. But the harder truth is that none of those dramatic moments happen without the smaller ones. It happens because a court reporter's hands kept moving and captured every word. It happens because a bailiff chose to give a voluntary statement instead of saying he didn't want to get involved. It happens because two jurors, private citizens who owed nothing to anyone beyond their duty to serve, picked up the phone and called the Judicial Conduct Commission and said, "We need to tell you what we witnessed." It happens because Sandra Oku stood up, not because she was sure she'd win, not because she had a clear procedural path forward in that moment. She stood up because she understood that the alternative, sitting down, staying quiet, accepting what the judge had just done, and moving forward as though it hadn't happened, was something she couldn't do and remain who she was. That distinction matters. Between the attorneys who stay in their seats because they've calculated the risk and decided it's not worth it, and the attorneys who stand up because they understand that some moments don't allow for calculation. Accountability in institutions doesn't come from the institutions themselves. It never has. Institutions are made of people. They protect what the people inside them decide to protect, and they correct what the people inside them have the courage to correct. The Crestfield County Courthouse still operates. Cases are still heard. Juries still deliberate. The process continues, as it must, because justice isn't a destination. It's a practice, daily, imperfect, always in progress. But something changed in that building after Gerald Weston was removed. Attorneys who practiced there in the years that followed described it as subtle, a different atmosphere in the courtroom, a sense, harder to quantify but real, that the building had passed a test, that it had proven, through a painful and public process, that it was capable of enforcing its own standards. That kind of institutional memory matters more than most people realize. Because the question that an entitlement like Weston's always ultimately poses to the system around it is not simply, "Will you catch me?" The deeper question is, will you actually do something about it when you do? For most of 17 years, the answer from Crestfield County was incomplete. There were complaints. There were findings of insufficient evidence. There was quiet filing away. There was the protection that institutions extend to themselves when they're more committed to their own continuity than to their own integrity. And then there was one afternoon when a judge went too far, when he made his corruption visible, explicit, and witnessed, when he put it on the record in a room full of people who understood exactly what they were seeing. And the answer, when it finally came, was clear. What this story ultimately teaches is not that systems always work. They don't. Anyone who has spent real time around courts, around law, around the machinery of institutional justice, knows that it fails regularly and in ways that are both dramatic and mundane. Cases fall apart because of procedure. Evidence gets excluded. Powerful people get protected. The right attorneys cost more than most people can afford. Justice is real, but it is not automatic, and it is never guaranteed. What this story teaches is something more specific, and in some ways more important. It teaches that there exists, within broken systems, people who have not been broken by them. People who still understand why the rules exist. People who, when the moment comes, choose to stand up. Those people are not always recognized. They're not always safe. Sandra Oku took a professional and personal risk in that courtroom. Howard Gaines and Patricia Delgado took a risk when they called the commission. The bailiff took a risk when he gave his statement. They did it anyway. And because they did, a 17-year judicial career built partly on impunity came to an end. A group of elderly investors who had spent 2 years watching their retirement savings disappear into litigation got a verdict that gave some of it back. A courtroom that had been quietly compromised for years was, at least in that moment, restored. Elaine Marsh closed her yellow notebook. The court reporter's transcript went into the public record. And somewhere in a law library or a legal journal, or the memory of a young attorney who was in that courtroom and has never forgotten what they witnessed, this story continues to do what all true stories of accountability do. It reminds us that what we choose to do in the moments that matter is not just the measure of who we are. It's the measure of what we make possible for everyone who comes after us.